For the record, Representative Crane, District 12 in Nampa. First, want to start by talking about our Idaho Constitution. I went and looked this up last night, and in our Idaho Constitution, Article 3, Section 24, it says promotion of temperance and morality. The first concern of all good government is the virtue and sobriety of the people and the purity of the home. The legislature should further all wise and well-directed efforts in the promotion of temperance and morality. That's from our Idaho Constitution. In a 2003 landmark case of the United States versus the American Library Association, all members of the U.S. Supreme Court agreed that libraries have a legitimate and a compelling interest in protecting young library users from material inappropriate to minors. According to an IFPC poll conducted in December of 2022, 74% of Idaho voters believe that it is important that libraries keep obscene and harmful materials away from minor children. So, what's the purpose of this bill? This bill requires that public school and community libraries take responsible and reasonable steps to restrict children's access to material that is obscene or harmful to minors. I'd like to start out by walking through this bill with you. There's been several narratives, if you've looked at your email, that have been framed about this bill, and many of you haven't even read this bill. I'm not offended by that. Most of the people who sent out those emails have never read this bill either. So I want to talk a little bit about that. First and foremost, this is not a book ban bill. We are simply asking libraries to take a reasonable step to restrict this material from minors. If an adult chooses to access this material, that's up to the library. That's not what we're talking about today. We're talking about children. It's fair for tax-paying parents to know that if they send their kids to a public library, community library, and there's harmful material in there, that they shouldn't have to worry that those kids just easily access that material. A point of clarification for us here: if you distribute this material to a child outside of the library, whether it's the library steps, a 7-Eleven gas station, a bookstore, you're getting prosecuted criminally. But if you walk backwards 12 steps into the library, all of a sudden it's okay. That's what we're talking about here today. So, false narrative number one. You are trying to punish librarians, these poor librarians. No. We greatly appreciate our librarians and their service to the community by what they do. This bill uses common law doctrine, and I'm going to give you an example of what that is. Last week, one of our employees at our company broke a window at someone's home. We met with our general manager on Monday for lunch, like we always do. And he said, "What do we do?" He's a new general manager to us, and we said, "We pay for the window." That's exactly what is in law right now, and that's exactly what this bill does. It protects the librarian by saying the Board of Trustees is responsible, not the librarian. So I want to get in front of that narrative. This isn't about the librarian. And that common law doctrine is known as respondeat superior. So, library boards. I went last night and I looked up, and you can look this up as well right now if you have your laptop, boisepubliclibrary.org. Right there on their website, they help us out quite a bit with this. You go right down to the homepage under the board structure and responsibilities, and this is exactly what it reads on their website. The library board sets policy for the operation of the public library. By law, library boards in Idaho are responsible rather than advisory boards. So, we're not trying to punish librarians. False narrative number two. Kids have access to this material on their phones. This bill is about libraries. This is not about cell phones. It's not about your personal devices. It's about libraries. These are public, tax-funded facilities, and that's what we're talking about. False narrative number three. The civil penalty is too high. To all the members on this committee, your chairman and other members of the majority caucus voted to pass House Bill 666 last session. That had criminal penalties in it. This has been scaled down to civil penalties. Okay? So, even then, each of you on this committee, I say and I say again, I would make an effort I'm a business guy. If we need to talk about the civil penalties, we can talk about that. That's fine. I'm open to that. So I'm going to yield my time now to Blaine Gonzatti. He's going to come up and share some things.
Your for the record information, and the floor is yours.
Yeah, thank you, Madam Chair. My name is Blaine Gonzatti. I serve as president of Idaho Family Policy Center. And as the other bill's sponsor just explained, the Children's School and Library Protection Act creates a duty of care for schools and libraries by ensuring that they take reasonable steps to restrict children's access to obscene materials. Let me assure you guys, this legislation is defensible. There is no First Amendment right to disseminate obscenity to children, period. This legislation uses a modified version of the Miller test. And the Miller test, as you all know, was promulgated by the U.S. Supreme Court in 1973 to define which materials qualify as obscene. Subsequent decisions modified this test, applying it to minors. Prohibiting libraries and schools from distributing books or other material that fall under this definition of obscenity complies with the necessary federal court decisions, helping to ensure the defensibility of House Bill 139. In fact, the U.S. Supreme Court, as Representative Crane said earlier, has ruled that state governments and libraries both have a compelling interest in protecting minors from obscene material. This makes sense when you consider the state's responsibility in protecting the public health, safety, and morals, especially of minor children. That's why the state of Idaho has long declared its policy in 18-1513 Idaho Code of restraining the distribution of material harmful to minors because, quote, such materials are a contributing factor to crime, to juvenile crime, and also a basic factor in impairing the ethical and moral development of our youth. Additionally, the state of Idaho has a compelling interest in protecting the fundamental right of parents to nurture and direct their children's upbringing, education, and destiny, which undoubtedly includes protecting the right of parents to shield their children from pornographic materials. We can talk about the legal ins and outs of this legislation until we're blue in the face, and I'm happy to do that, but let me be real honest with you guys right now. About the problem that this legislation aims to correct. Idaho Family Policy Center recently released a report detailing that this is a widespread statewide problem. Now, of course, not every school and not every library distributes smut to kids. But according to our investigation, public schools or public libraries in nearly 30 cities throughout the state of Idaho currently make obscenity available to children. Let me repeat that, because that was startling to us when we found that out. Public schools or community libraries in nearly 30 Idaho cities give children access to obscenity. That's disturbing. It explains why nearly 74% of likely Idaho voters support legislation that requires public schools and community libraries to keep pornographic materials away from children. Do right by these kids and do right by these parents. Please approve the Children's School and Library Protection Act, House Bill 139.